Hey, was there any proper legal motive for such a scheme?
I can think of none.
So you would conclude that such a scheme had to have an illegal or extra-legal motive?
Well, I don't doubt that the scheme, if we can use that word, was motivated by an intention to protect the United States.
That's not the question.
But
let me just observe, because I want to comment also on the comments by Mr. Rohrabacher before. Lots of terrible things have been done in history by people who are well motivated to protect their country or other noble goals. The reason we have laws and due process is to protect people from men and women of zeal who may be perfectly well motivated. So that's not the question.
And I agree with that.
And if somebody has the motive of protecting the United States, and in order to do that, does illegal things, we have laws because we don't trust people's even well-intentioned motives to protect all of us.
Completely agree with that. I was just trying to be completely comprehensive in my answer. There is no question but that, given everything we know, the intention here was to render him to Syria as opposed to Canada because of the certainty that he would be tortured in Syria and he would not be in Canada.
And the intention was to take whatever shortcut possible so as to avert any legal challenge, such as a writ of habeas corpus, that he could bring, which would have stopped that rendition.
That, to me, is the only reasonable conclusion that can be drawn from it.
Is there anything in our law that would stop them from doing it tomorrow to somebody else? Mr. Irvin?
Well, yes. I mean, the laws prevented this occurrence. It's just that the laws were not observed.
You think they broke the laws?
Yes.
Do you think there were criminal violations of the laws?
I think there should be a criminal inquiry.
What possible criminal laws might have been violated? Excuse me. What criminal laws might have been violated?
Well, we are a signatory to CAT.
Oh, yes. CAT, okay. And CAT's a criminal statute?
I believe that a failure to observe this International Convention of Torture would constitute a violation of criminal law.
Okay. Professor Horton, could you answer the same question, please?
Yes. One of the provisions implementing the CAT was Section 2340A of the Criminal Code, which makes torture and the conspiracy to torture a person a criminal offense.
And any high official who engaged in I'm trying to look for the word that doesn't have improper connotations. Any high official who engaged in a course of conduct with the intent of depriving Mr. Arar of certain legal remedies so that he could be rendered to Syria with the knowledge that he might or probably would be tortured would be guilty of criminal offenses?
Well, I think, there's certain defenses built into the statute and built into the CAT that one would have to work one's way through. So there's a proper...
Well, clearly, but assuming those facts were proven.
Prima facie, yes. I think a prima facie case would be made out here, yes.
Mr. Irvin?
Yes, I agree.
Mr. Skinner, do you agree?
That's correct. And let me also add, if you asked can this happen again, I think with the new policies and procedures put in place, it would, not to say it cannot happen again, it would be more difficult for it to happen again.
Well, and one of those, I'm told, one of those new procedures is redacted because it's a secret procedure?
That's correct. I'll be happy to talk to you about that in the classified environment.
Now what, Mr. Skinner, given the extraordinary secrecy of this, given the extraordinary secrecy from the beginning until now, what assurances does the American public have that anyone walking down the street can't be, well, other cases of rendition? Well, let me ask you this. We've looked at a number of rendition cases. This is the only one which, am I correct that this is the only one in which the immigration laws were used as a pretext or a fig leaf, or which was done supposedly under the immigration laws?
As far as I know, correct.
And other cases of rendition that we know of were done just completely outside the law?
Well, they were done outside the territory of the United States, so that U.S. immigration laws don't apply to them.
So they were all done outside the territory of the United States. But the CAT still applies and the other criminal laws still apply. Mr. Irvin, given the extraordinary secrecy and the evident use or misuse of classification and secrecy to cover up improper conduct, what would you recommend? What changes would you recommend so that American people could be more confident that official misconduct, official torture, official law breaking would not be covered up by the secrecy laws?
Well, I'm very concerned by this tendency that we've seen in the last few years to overclassify information. And in preparation for this hearing, I reviewed the mechanism that is available to challenge what one considers to be overclassification. And the bottom line is, at the end of the day, the ultimate appeal is to the president. And in these circumstances, it's needless to say.
Only the executive? Congress can't declassify something if it wishes?
My understanding is the answer to that is no.
I'm told except by a vote of the full House.
Well, then, if that is true, then that's your remedy. But
it's a rather difficult remedy.
Needless to say, but less difficult under these circumstances than appeal to the president, of course.
And okay. Yeah, Mr. Horton, Professor Horton, do we know who the ODAG lawyers who were involved in this were?
They've been identified to me, yes.
And that's public knowledge?
I am not sure it's public knowledge.
No, it's not public. They're protected under the privacy laws.
And did they cooperate with your inquiry?
Yes.
What about the acting attorney general, Mr. Thompson? Did he cooperate?
I don't believe we reached out to the acting attorney general.
Well,
was he not
identified at some point in your report that serves as having made some of the key decisions here?
I believe he
surrender into Syria.
I don't believe he was involved in the decision to remove Mr. Arar to Syria. He made the decision, I believe, that we would not honor Arar's request to go to Canada because of the porous nature of our borders.
Because it's prejudicial to U.S. interests.
Yes.
Now, given the fact that he made that decision, and he seems to be a key actor in this, why did you not seek to interview him?
When we were doing the review, I think the questions that we were asking could have been answered up through the Deputy Attorney General and that office.
Yeah, Mr. Skinner, you concluded there's not, I think your report concluded that there's not enough evidence to justify that determination. Or didn't you conclude that? Or that there's not enough evidence, you don't have enough information to judge that determination with respect to Canada?
That's correct.
Therefore, didn't you think that being the case, shouldn't you have sought further evidence, like by interviewing him?
Well, I believe he signed the letter, but it was the recommendations that came from the Office of the Deputy Attorney General.
And did you interview the Deputy Attorney General?
And we did interview those individuals that were involved.